Yeah, so let's talk about the New York State Pistol Rifle Association. I'll just talk about it because I skimmed the transcript. It's very technical in a way that is like just not interesting. It deals with, I mean, it's barely interesting to lawyers. In fact, it's really not. But let me tell you what happened in the case about it. Okay. All right. So New York State and New York City, more particularly, had a law, a regulation on the books, and this regulation applied to a permit license to own a handgun. So New York State, New York City has at least two different kinds of gun licenses. They have a premise license and they have a carry license. A carry license allows you to carry a firearm, concealed carry. A premise license allows you to have a handgun in your premises, whether that's a business or a home. Um, the way that the regulations in New York City were drafted, uh, it said you could take the handgun on an uninterrupted trip to like any gun range or like uh, gun store, gunsmith within the five boroughs of New York City. But you couldn't take it from one home to another. So if you happen to own two homes in New York City, you couldn't take it from one home to another, and you couldn't take it to a gun range outside of the five boroughs. So not just out of state, but outside of New York City. So if you had a premise license, you had to take it to a shooting range within the five boroughs, and it had to be an uninterrupted trip, and that was what was going on. The Court of Appeals ruled that this was totally cool and totally not a problem. And the New York State Rifle and Pistol Association applied for certiorari. And the city of New York, or state of New York, I forget which one actually filed the brief, not that it really matters in this context. But the state of New York filed a brief on the question of whether cert should be granted, which is very typical. And they basically said cert shouldn't be granted. They said, there's no conflict. This is our law. We totally are proud of our law. We think our law is the greatest. We're really proud of our law. The court below said our law is totally cool. There's no reason for you to take this case. We stand by our law. Our law is totally great. Then the United States Supreme Court granted certiorari. Then New York went into a panic. New York panicked. And this is not the first time we've seen this happen. For those of you who may not remember, and I wouldn't expect you to, Illinois at the time had no issue permit. So some states are shall issue, some states are may issue, and some states were no issue. So Illinois had a no issue. They didn't issue concealed carry license or open carry licenses to anybody. Illinois lost in the Seventh Circuit Court of Appeals when that issue came up. And Illinois decided not to appeal. Illinois changed from no issue to shall issue to avoid that issue going to the United States Supreme Court. Same thing happened to Washington, D.C. Washington, D.C. didn't issue permits to anybody. They lost at the Court of Appeals for the D.C. Circuit. They decided not to appeal. They went from no issue to shall issue. It's a bit of a cumbersome shall issue, but still they will issue a permit to anyone who is qualified. And there was the case of Padilla in California, where like California basically changed the rules to prevent the Supreme Court from hearing the case. And New York did exactly the same thing here. So in between the time, but now this time New York had won below, so they didn't have to decide. They didn't have the right to decide whether or not to appeal. They told the court they shouldn't, but they didn't have the right to decide. The court took the case. So New York went into a total panic because they don't want the Supreme Court to decide the case. They don't want precedent. What they're trying to avoid is precedent on a right to bear case. They're trying to keep gun cases out of the Supreme Court because they don't want gun cases being decided by the U.S. Supreme Court. They don't want precedent being set nationwide. So every time it has gotten close, every state has gone into a complete and total panic to do anything possible to prevent this from being heard by the United States Supreme Court. And that's exactly what happened here. The New York City police, if memory serves correctly, very soon after certiorari was granted, published a new set of regulations. These new regulations said it's totally cool if you want to take your gun out of your house and take it outside the 5 boroughs. You can take it out of state. You can take it to your different house. You can take this gun anywhere you want. New York City, which had about 2 months earlier said we're super, super proud of our law. Our law's the greatest. It's totally necessary. We love our law. The law's super wonderful. 2 months later, the commissioner of police said, "Oh, we hate our law. No, that law's stupid. We don't like that law anymore. We're going to pass new regulations that say, you get everything you want. You get a car and you get a car and you get a car. Everybody gets a car, right? So we're going to give you everything you want in terms of regulation." So the police commissioner, as memory serves, put out a new regulation that says you can take your gun outside the 5 boroughs. You can take it to a different house. Oh, and incidentally, no one who has ever broken the law, and they said this in the oral argument, they said this because one of the things they asked about was, what about anyone who's ever broken the law? And the lawyer for New York said, no, none of those people are ever going to be punished, ever. No, none of those people are ever going to be punished. We disclaim any right to punish any of those people. We're never going to bring a case for anyone who ever broke the law. And it's like, really? Because in the opposing side's brief, they have like basically 3 people who openly admit on the record in like Supreme Court filings, they openly admit in the filings that they've broken your law multiple times, and the attorney for New York is like, nope. It's totally fine. We're totally fine. They have no criminal exposure. We disclaim. We give up all those cases. They're totally in the clear. We have no interest in this. We give up. It's fine. So they get everything they want. No problem. And just in case that wasn't good enough, New York City ran screaming to Albany, the state capital of New York, and got the state legislature to pass a law in a 2-month interval. These guys are bawling. They are bawling. They are scared out of their minds. They run up to Albany and you got to pass a law right now. And so the state legislature passed and signed a law in record time. Basically says the city of New York has no power to ever pass any regulation like this ever again. We, the state legislature, completely strip from the city of New York any power to pass any regulation like the one they used to have. New York City has no power. We, the state legislature, find this abominable. We totally destroy New York City. And New York City's like, yeah, we're totally cool with this. So that's basically what happened, is they ran up to the legislature just in case and got a law passed that says you can never ever do this again. New York City, you are but a creature of the state. You will bow to our will. Blah. And so they got Albany to pass a law just to make sure that so it's well, what if, because one of the arguments is, well, what if you just change your mind? What if you just change the regulations? So they went to Albany to get a law passed and signed that says, no, we can't even do that because it's now a violation of state law. We specifically prohibited ourselves from ever doing this ever again. We want none of it. We've given them everything they want, so they have no case. Article 3 of the Constitution applies to cases and controversies. The Supreme Court of the United States does not do advisory opinions. They don't do what would happen if. They only do live cases and controversies. It's in the Constitution. So it's not so much as they don't as they can't, at least as far as the constitutional text is written. So this is what the entire argument at the Supreme Court turned into, was an argument over whether or not it's moot or not, whether or not there's actually a case. And New York's entire argument was there's no case. There's no case of controversy. There is no exposure. We've given them everything they want. We've changed the regulation to be exactly what they want. There's no exposure, and we sitting here today as the lawyer on behalf of New York, the lawyer on behalf of New York, am here to tell you, the Supreme Court, that we will never, ever, ever prosecute these cases. And incidentally, by the way, that is absolutely a binding statement. So like when they say that, that's like actually true. You can't just say that. That's like when you say that to a court, when you say that to the U.S. Supreme Court, it's true. So like that's not something they can change their mind on, incidentally. That's like we have given this up. I, on behalf of the state of New York, because I am the attorney for New York, I am the state, and I'm telling you that we are disclaiming this. We have no claim. We're giving it up. And you can do that. It's one of the many wonderful powers you get as an attorney, right? When you represent someone, you can do shit like that and make representations, and they become binding. So they said, so that was what the entire argument was about, was whether it's moot. And it got into really pedantic issues, like if there's any issue that wasn't resolved, if there was anything like any exposure, anything at all, that like, the one of the things they actually got into was, because it says in the regulation from New York that it has to be like, I think the phrase is uninterrupted and continuous. So like when you're taking your gun from like one place to another place, it has to be uninterrupted and continuous. And so there's some questions like, well, what does that mean? And like, and even then, New York was desperate for there not to be a jurisdiction, because it's like they're still in, this was basically the exchange, okay? I'm paraphrasing, but this is basically the exchange. It's like Supreme Court says, what does that mean? Isn't there some exposure there? And Supreme Court's like, and the city of New York's lawyers like, no, there's not. They said, well, continuous and uninterrupted sounds kind of ambiguous. We're not sure what that means. No, it's totally fine. What sort of problems are you considering about? Well, what if someone stops for gas? No, they can stop for gas. Really? They can stop for gas? Oh yeah. They can stop for gas. Yeah. But it says continuous and uninterrupted. No. They can stop for gas. Totally fine. Yep. What if they need to stop for the bathroom? Oh, bathroom, totally fine. Yep. But it says continuous and uninterrupted. Yeah. But bathroom's totally fine. The bathroom, gas, totally cool. Yep. Really? Well, what if they have a flat tire on the road? Yep, no problem. Nope, that's fine. All that's fine. And like it got down to the point, they literally asked this at the U.S. Supreme Court. I'm not making this example up. They literally asked, well, what if like you're visiting your mother and you stop at your in-laws' house? Is that okay? And they're like, well, we're not so sure about that one, but sure, why not? Even that they wouldn't say no, it wasn't okay. They wouldn't say yes, but they wouldn't say no. So even the like, if you're visiting your mother, can you stop at your in-laws? It's like, well, we wouldn't worry about it, and if it ever came up, but that's another issue for another day. And like, so New York City is desperate to keep this out of the United States Supreme Court. So, like, it was just a little funny in that way, watching New York City. Like, please, what do you want? We'll give you anything you want. Please, we'll give you anything you want. We don't want this case. Please, what do you want? We want this to go away. So that was what it's about. So what is the outcome going to be? Well, there is one doctrine which talks about voluntary cessation. If like this state is like voluntarily giving up their right to do stuff to avoid review, right? So they'd like drop this case, but they could bring it back. But that's one of the reasons they went to the U.S. They went to Albany, like running to Albany, because of the voluntary cessation doctrine. Because the voluntary cessation doctrine basically says, look, if you're just like dropping this case to avoid judicial review, but you can bring up it again, like screw you. We understand we understand what you're doing. You're just going to drop this prosecution and prosecute the next guy and prosecute the next guy and prosecute the next guy. And anytime it ever gets to the U.S. Supreme Court, you're just going to drop that case. 99.9% of them will never get that far. And for the 0.1%, you're willing to sacrifice them to the altar of the law gods just so you don't have to do it. So there is this doctrine of voluntary cessation. It's like if you're just like voluntarily doing it, we're going to say screw you. That's exactly why New York City went screaming to Albany to get them to pass a law. Says, no, it's not voluntary. It's not voluntary. We had to do it. We had to do it because Albany said we had to. We can't just bring this law back. We have no power. We have no ability to bring this back. We can't prosecute. This is illegal. We can't operate in this domain. Woo! And so that's exactly why they fled to Albany, like running like running from the bulls kind of style, tripping over themselves to see how fast they could get there because of specifically that issue. And that's the reason they did that, is because of that issue. So like even that is like, you know, not really on the table. So I think the overwhelming odds are that the case is going to get dismissed as improvidently granted. It's going to get digged, and in light of the mootness, because it's like there's nothing to do. So that's why we didn't do the oral argument for Evil Tribble and Dogbert. That's why we didn't do the oral audio. The oral audio for the case, because I skimmed the transcript. I skimmed the transcript. It's really minutia on mootness doctrine. It's everything I've done in sort of describing it is way more interesting than the argument was. I have animated what was really a very boring discussion. So like, if you want to go read the transcript or listen to the oral argument yourself, it's like, it's posted. It's not like it's secret. Go listen to it yourself. I just don't think that there's anything interesting there. It's really like hyper technical minutia on mootness doctrine. And like, it's just like, it's too esoteric, it's too minor for us to talk about. You know, might the Supreme Court do something about it? Yeah, but like, you know, I have no way to predict it. I have no way to do it, because like the only thing the Supreme Court can do would be change the law. Like if they follow the law, if they follow like what the law is, the answer is pretty easy. The case is moot. I think it has to be. And like anything else is speculative, and anything else is like, it's moot. So like if they follow the law the way it is, it's moot. So like 98%, they're going to dismiss as improvidently granted, because there's nothing to do here. They're going to dismiss as improvidently granted and be like, yeah, we just, and then the only interesting thing about it becomes whether or not like they do it in a one-word sentence, or whether or not like people put in some opinions on top of it, whether or not they like expound on stuff for the record, you know, because it'll all be technically dicta, but then again, it's Supreme Court dicta, so, you know, people do take that seriously. So like, you know, that's really the only interesting question, is whether or not they write any opinion about it. But like, how am I supposed to be able to predict whether they write an opinion about it, or whether or not they just dig it? I mean, I know what the outcome's going to be. It's 98% they're going to dig it. With or without commentary, I don't know. But that's really the only interesting thing. Like, the only other remaining possibility is like, they invoke some like judo stuff about like ever recurring but evading review, or like overturn mootness doctrine, or something like massively like changing the law. But if they're going to change the law like that massively, there's nothing on the oral argument that indicates the court is interested in doing that. So there's nothing that I saw that says the court is like looking at massively overturning mootness doctrine. So like, I guess they could, but there's nothing on the like transcript that indicates anything like that to me, that like they're looking to do that. And if they do, it'll be a complete surprise out of left field, and there's nothing on the oral transcript that would tell us or forecast for us what that would look like. It would be a massive change in the law. And so I have no way to like see what that is, because, you know, I as a lawyer can make reasonable predictions based on precedent. And like, I can even make reasonable predictions on like overturning precedent sometimes, because I'm like, well, if you overturn this precedent, then like these kinds of results would tend to emerge. But like, if they do something here, it's like I can't forecast it. There's nothing for me to forecast it against. It would be a very serious change in the law, and there's nothing for me to like forecast what that would be. And I don't think it's particularly likely, because there's nothing on there. So I think that's why we didn't do the case, because it's just boring. It's very, very technical minutia. And so like, it's just nothing for us to talk about. So